Okay, so there are all sorts of matters that relate to intellectual property, from the um, drafting of the CIIA agreements. The Cooley form CIA is on your syllabus as an assignment for you to review this module, to ensuring there are adequate protections in place for all the trade secret information, to documenting the creation of copyrights and deciding which copyrights to register and when, to doing brand checks. So what happens all the time is the marketing people come up with a name for a product and they get all happy about it and hyped up about it. And then they come to you and you do an analysis of whether or not it's a strong mark. And then you got to do a clearance check, or what we call a knockout search. And you might have to give your client bad news that someone else already has that mark registered or reserved. So it's usually best to tell clients, when you start thinking about brand names that you want to use, talk to me early on so we can make sure you don't spin your wheels and waste it investing a lot of time and money in a mark that someone else already has rights to, or that isn't a strong protectable mark. When it comes to patents, you have to get disclosures of inventions and then draft applications and file those with the patent office. So there's lots of work to be done in protecting the intellectual property, dealing with threats from other parties with intellectual property, deciding how to defend your intellectual property from infringement by others. There's all sorts of matters that can come up. So I'm just going to go through some examples here that illustrate what these are. So here's a great example of a startup called Zest Labs. They had some trade secrets. This is a trade secret case regarding freshness management, and they worked hand in hand with Walmart for a long time. Walmart said, "Hey, we like your technology. Let's work together and figure it out." And then, as happens a lot, Amazon has done this, Microsoft has done this. Like most of the big companies will do this as startups. They'll work with them for a while. They'll learn how they do their secret sauce, how they do their product or service, and then they'll just start doing it themselves, and they'll just leave the startup in the dust. And so your recourse as a startup is to either let them get away with that or pursue them for violation of your intellectual property rights. So this is a case about this startup, Zest Labs, who says, Walmart came in, worked with us. Down here you can see it was a multi-year relationship. They had significant discussions, presentations, demonstrations, and product trials with Walmart. They're saying, look, we told you everything, and then you went and took our ideas, there's a Zest Labs CEO says, we were surprised and concerned by how similar Walmart's Eden description was to Zest Fresh. And they stole the same idea. So pursuing them for trade secret violation. Now, if they had good lawyers, they should also have a non-disclosure agreement. So you can bring not only a trade secret case, but also a breach of contract case. Here's a really cool little trademark matter. So the Uber that we all know and have used, I'm sure, countless times, when it wanted to move into Gainesville at the University of Florida, there unfortunately was another transportation company there, a limousine company, that was using the word Uber. And so the Uber that was already there, even though it's not here's the name of the company here, the Uber Promotions, Inc. So Uber Promotions, Inc. was already operating in Gainesville. The nationwide Uber decided it wanted to start operating in Gainesville, and Uber Promotions had senior rights because it was using the word Uber for transportation services before the main Uber. So this brings home another point about trademark law. Not only are your trademark rights limited to the product or service you're using with, they're also limited to the geographic area in which you're using it. So if you're using Uber in California and someone else is for car services and someone else is using Uber in Florida, that's okay because you're not in the same geographic market. Now, if you register your trademark with the Federal Trademark Office, you're presumed to have nationwide usage. And of course, these days, most people are online, which generally gets interpreted as nationwide usage. But in this case, the small little Uber Promotions had prior rights over the now publicly traded Uber Technologies company. You can see there's actually a district court judge that had issued a some kind of an injunction or temporary restraining order based on Uber Promotions rights. Here's another kind of funny video. I want you to, these two gentlemen here are the clients, and you're the attorney here on the right, the woman. So just think how you would respond in this situation if these clients came to you as the attorney.
You're pretty aware that Coke Zero tastes a lot like Coca-Cola.
Yes, in fact, my son adores it, and I buy it every week.
Perfect, because we feel that there might be some taste infringement issues.
Between these two?
Yes.
Oh, so you're worried about...
I think it's basic taste infringement. I'd like to stick with that phrase, because that
Right,
sounds
but
really good
it's
to me.
not
I don't know what a good analogy would be, but are you familiar in the music industry of sampling? It's like we've laid down a really good baseline,
Right.
you know, and Coke Zero's come along and just added something on there.
What's...
Just basically a patent copyright, a little too closely.
What would be equivalent to a corporate kick in the balls?
You don't have a valid claim. You can bring a suit, there's no claim.
I picked up on something you said. You said age. This product is 100 and some odd years old. We're talking about a young product. You don't think it's age discrimination against an older product? We can't.
It's
Why
not
can't
a
we?
person. Title VII doesn't cover these things.
Ron, on more than one occasion, has pointed out that Matt is bald. Is that age discrimination? Is that
No.
discrimination in any way against
No.
the hairless?
No. Hairless are not protected.
Could we sue them just to get it into court to just humiliate these
dismissed.
people?
You'll be humiliated, and you'll
We'll
get
be
fired.
humiliated and
you'll
fired.
get fired.
I don't want that.
So obviously this is all tongue-in-cheek. Coke Zero, when it was released, Coca-Cola made a bunch of these ads involving hidden cameras of lawyers being asked to represent the original Coca-Cola versus the new Coca-Cola Zero. And, you know, having said that, you'll have clients who ask questions like this, like, can't I sue them for taste infringement? And you just have to come back and say, okay, let's think of what of the 4 intellectual properties rights could this be? Is this a trade secret? Well, can we prove that they misappropriated your trade secret? Now, notice you don't violate someone's trade secret by coming up with the idea on your own. Right? So if someone came up with an idea for apple pie and you come up with an apple pie, you haven't violated their trade secret unless you stole their recipe for apple pie. If you came up with apple pie on your own, that's not a violation of trade secret. There's no trade secret here. There's no copyright because there's not an original work of authorship here. Maybe there's trademark, right? So if a competitor wanted to sell a product called Coca-Cola Zero and you represent the main Coca-Cola, well, Coca-Cola Zero is using the same mark that you own, Coca-Cola, to sell a competing product. So there could very well be trademark infringement if this was a separate company. Patents, we don't know of any patents being issued. There could be patents issued on beverages and foods. They're chemical creations, so it's possible. But we'd have to see whether or not there was a patent owned by our client. But, you know, a side good lesson from this video is you're going to have to be able to tell clients no. A lot of attorneys, especially young attorneys, don't like giving clients what they think is bad news. And you think, well, if I tell the client no, or if I tell them they have a weak case or that they have no case and they'll get embarrassed, that, you know, the client's not going to like me, I won't get hired. In the long run, it's always to your advantage to just tell the client the truth. In fact, lower their expectations. Don't ever tell a client, oh, yeah, this is a slam dunk, you'll definitely win, because you're only setting yourself up for disappointing the client. You know, it's always better to underpromise and overdeliver. So her reaction, I think, is just perfect. You know, she's not going to just tell the clients what they want to hear in order to get the job or to make them happy. She's going to tell them the truth as she sees it, and that's definitely what a good lawyer should do. Okay, here's a good way to think about patents. So file and maintain your own patents. That's what we talked about originally, you know, getting your own patents. then there's other uses of patents. You can use them, you can license them, you can justify your valuation. There's a friend of mine wrote a law review article that said startups with patents get more funding at higher valuations than those without. So even if you don't intend to sue anyone for infringement, you don't have the ability to sue anyone for infringement, you're worried about the patent getting killed in one of those review processes that we saw the documentary trailer about, it still can be beneficial to at least have some patents in your name. And then here's the risk where you have to worry, watch your back, you have to worry about what other patents may be out there that could be asserted against you that you would need to worry about. Okay, here's an interesting matter that a friend of mine did when he was in-house counsel at Twitter. So Twitter has a lot of computer programmers, engineers on its staff. And generally, computer programmers hate lawyers. They just do. Most scientists hate lawyers. They think we just waste time on silly things. We take away money that should be used to fund product development. So one thing in particular software developers hate is patents. They think patents are just a way of slowing down development and the government mucking up software development, and that patents aren't needed to incentivize software development. Well, that's how the engineers at Twitter felt. They said, we are not going to help Twitter get patents. Twitter went to them and said, hey, you've got all these cool inventions that you're implementing through Twitter. Help us get patents. The engineers are like, no way, we are never getting patents. That's against our ethics. Well, the investors in Twitter, the owners of Twitter, said, we need patents to protect our moat. I mean, how are we going to prevent Facebook or anyone else from just copying what we're doing and putting us out of business? And so my friend had to come up with a solutions problem. How do we keep the engineers happy by not getting patents? And how do we keep our investors and our owners happy by getting patents? It would seem insurmountable. Well, what he did is he started asking people more questions, especially the engineers. What is it about patents you don't like? And the engineer said, well, we don't like patents being used to stop software development. I said, okay, what if Twitter made a promise to you that if you help us get patents, we won't use them to stop anyone else from doing software development? We will only use them as a self-defense. If someone sues us for patent infringement, then we can counter-sue them for infringing patents. And the engineer said, you know what? That's okay. We're okay with that. If you will promise us that you will not use our patents to stop anyone else, you only use them for defensive purposes, then we will help you get patents. So that's what he wrote. He wrote this innovator's patent agreement. And it's as it's described here, it's a new way to do patent assignment that keeps control in the hands of the engineers and designer. It is a commitment from a company to its employees that patents can only be used for defensive purposes. The company will not use the patents in offensive litigation without the permission of the inventors. This control flows with the patent, so if the company sells the patents to others, the assignee can only use the patents as the inventor intended. So this was a very creative legal solution to the problem of keeping the talented software engineers and designers happy by not getting patents that they thought would be used in a harmful way, and also keep the investors and owners happy. So this is a great example of a very out-of-the-box kind of creative legal solution to a real problem for the business. Okay, as another matter, let's watch this video. So the what's happening here? Okay, so your discussion board question this week. Let's see if I can get this to come up another way. Right. So this is your client. The discussion board for this week says, this is your client, Grow Buddy. It's a startup in the marijuana industry out in Colorado. this is your client, and they've hired you to help them develop an intellectual property strategy to help protect their moat, create their monopoly. We're going to play this video, and then after the video, I want you to go to the discussion board and contribute what you think would be your recommended strategy for the company when it comes to intellectual property.
We're passionate about marijuana. We've been working with growers to make growing marijuana easier, more organized, and yield better results. That's how we came up with GrowBuddy. It's a simple but powerful app that tracks everything about your garden from beginning to end. Starting from seed or clone, every relevant detail can be recorded, including age and development stage, strain information, growing tips, and photos. Whether you're a hobbyist or a professional grower, GrowBuddy can help you maximize your yields and minimize your failures. We've got you covered no matter how you grow, soil or hydro. Stop guessing and start using the power of data to guide your grow with the most advanced yet easy to use grow management system. Grow like a pro with GrowBuddy.
All right, so that's your client, GrowBuddy. And in the discussion board, I ask you, what's your recommended IP strategy? So as you're thinking about this, it's best to just go through the chronological order that we've gone over. Trade secrets. Do they have trade secrets? How do they protect those trade secrets? Are there copyrights? Is anything here copyrightable? How do they protect those copyrights? Trademarks. There's actually a controversy right now. The trademark office will not let you register trademarks for marijuana itself. But can you get a trademark on GrowBuddy? Is GrowBuddy a strong trademark? Is that generic? Is it descriptive? Is it suggestive? Etc. Patents. Is there anything that could be patentable? You've been assigned in your syllabus the Alice Supreme Court case, which deals with the question of whether or not software can be patented. So I'm not going to answer that question for you. I'll let you read the case and answer it for yourself. Okay.